In some states, citizens do vote for judges. There are three main election methods: partisan elections, where judges are elected by the people and candidates are listed on the ballot alongside a label designating political party affiliation; nonpartisan elections, where judges are elected by the people and candidates are listed on the ballot without a label designating party affiliation; and retention elections, where judges run in yes-no elections without opposition to determine whether or not the judge remains on the court. Partisan elections are elections where judges are elected by the people and candidates are listed on the ballot alongside a label designating political party affiliation. Nonpartisan elections are elections where judges are elected by the people and candidates are listed on the ballot without a label designating party affiliation. Retention elections are elections where judges run in yes-no elections without opposition to determine whether or not the judge remains on the court. The federal court system in the United States has three main levels: district courts, the trial court, circuit courts, which are the first level of appeal, and the Supreme Court of the United States, the final level of appeal in the federal system. There are 94 district courts, 13 circuit courts, and 1 Supreme Court throughout the country. The nation's 94 district or trial courts are called U.S. district courts. District courts resolve disputes by determining the facts and applying legal principles to decide who is right. Trial courts include the district judge who tries the case and a jury that decides the case. Circuit courts are the first level of appeal in the federal court system. They review cases decided in U.S. district courts within their circuit. The appellate court's task is to determine whether or not the law was applied correctly in the trial court. There are 13 circuit courts throughout the country. The Supreme Court of the United States is the final court of appeal and the final expositor of the Constitution of the United States. It marks the boundaries of authority between state and nation, state, and government and citizen. The Supreme Court has the power of judicial review, which is the ability to declare a legislative or executive act in violation of the Constitution. A case can reach the Supreme Court in one of two ways: through its original jurisdiction or through its appellate jurisdiction. The Supreme Court has original jurisdiction over certain cases, such as suits between two or more states and/or cases involving ambassadors and other public ministers. Most cases reach the Supreme Court through its appellate jurisdiction, which means that the court can hear the case on appeal from a lower court. The most common way for a case to reach the Supreme Court is on appeal from a federal circuit court. The Supreme Court has the power to hear cases that relate to treaties, diplomats, and disputes between states. 1. It also has appellate jurisdiction over cases that involve a point of constitutional and/or federal law. 2. Some examples include cases to which the United States is a party, cases involving treaties, and cases involving ships on the high seas and navigable waterways, admiralty cases.